Good morning and good afternoon. Excellencies, dear colleagues and participants, welcome to the 5th Asia-Pacific Forum, which is organized in cooperation with the Hague Project Peace and Justice. The forum is held as part of the Hague Justice Week 2023, focusing on the topic of access to justice at the local, national, and international levels. My name is Maya, and I will be your MC. You will be able to follow 3 sessions today, and there will be an opportunity to ask questions via the Q&A box at the bottom of the screen. We hope to answer as many questions as possible as time allows. If you still have questions that we did not manage to get to, please send them to the email address noted in the Zoom registration confirmation. Please note this forum will be recorded. Lastly, before we officially start the forum, I would like to thank the European Union for the funding provided for this event. We now have the pleasure to hear the welcoming remarks from the ICC President, Judge Hofmański.
Ladies and gentlemen, I am pleased to welcome you all to the 5th Asia-Pacific Forum on the International Criminal Court. I'm very happy that we are continuing this annual tradition. I'd like to thank the Hague Project Peace and Justice for co-hosting this event with the ICC, as well as the European Commission for the financial support to make this webinar possible. This year is particularly meaningful as it is our first time to host the forum as part of the Hague Justice Week. I thank the Hague municipality and the organizers for making this possible. The ICC is proud to be part of the international community in the city of peace and justice. We can all make a bigger impact by collaborating with our partners. Before I go further, I should explain what we mean by the Asia-Pacific region in the context of the ICC. By this name, we are referring to a division of all the world's countries into 5 groups for the purpose of ensuring geographical balance in staffing and elections for top positions and so forth. The system was created in the United Nations and it is also applied in the ICC. Within the system, the Asia-Pacific is one of the largest and most diverse groups, as it spans almost half of the globe from the Mediterranean Sea in the west all the way to the middle of the Pacific Ocean in the east. This includes Western Asia, Central Asia, South Asia, East Asia, Southern Asia, and Pacific Island states. Unfortunately, the Asia-Pacific is the least represented region in the ICC system, with only 19 of the more than 50 countries in the region being part to the Rome Statute. This is regrettable, but for several reasons. First of all, it means that many states in the Asia and the Pacific are not able to contribute fully with their legal cultures to our global institution. For instance, the nationals of states that have not joined the Rome Statutes cannot become judges to the ICC. Secondly, all the hundreds of millions of people in countries that are not part of the ICC are lacking legal protection against the gravest crimes. If the national authorities in their countries do not take action against the perpetrators of crimes against humanity and other atrocities, there is no international system to fall back on to give the victims access to justice. This also means that there is less deterrent effect to help prevent such crimes from happening. So the question is how we can encourage and attract more states in the Asia-Pacific to join the ICC. I believe awareness raising is a big part of the answer, and that one of the main reasons why we are holding this seminar. In this regard, I hope today's event will help increase your understanding of the ICC's work. We have prepared sessions where you will hear stories of people working on the scene of international justice. ICC judges and staff members will share their first-hand experience and personal reflections about making an impact on access to justice. The ICC belongs to the people and the countries in Asia and the Pacific just as much as it belongs to any other part of the world. But the system is dependent on the sovereign will of nations to join the system and ratifying the Rome Statutes. Ladies and gentlemen, as we celebrate the 25th anniversary of the ICC's statute this year, it is easy to conclude that there is sadly huge demand of the ICC's mandate. The ICC is active in 16 countries on 4 different continents, including Asia, Europe, Africa, and South America. The judges of the court are hard at work with 4 ongoing trials, which keep our courtrooms occupied. The ICC's Trust Fund for Victims is providing reparative justice for thousands of victims in numerous countries. The prosecutor of the ICC is busy with multiple demanding investigations, some of them in ongoing conflict situations. We are motivated every day by knowing that what we do is making a real difference for the future of humanity. Justice and accountability today helps to prevent the conflicts and atrocities of the future. I hope some of you will be able to join us one day in this important mission. In this respect, I am glad the program contains a segment of career opportunities at the ICC. Thank you for being with us and thank you for your attention.
I will now give the floor to the moderator of the first session today, Ambassador Nora Stehauer. Ambassador, the floor is yours.
Thank you, Maya. Excellencies, ladies and gentlemen, good morning or good afternoon to you all. It's great that you could all log into this 5th Asia Pacific Forum, and I would like as a start to thank Judge Chung for the initiative he took 5 years ago. Thank you, Judge Chung. My name is Nora Stehauer, and I'm a former Dutch diplomat, and I'm a lawyer, and with great interest in the work of the ICC. I'm happy to cooperate with the ICC on this important event. So we will now have the presentation by Judge Chung and Judge Akane, after which we will go into the Q&A session. And as you have heard, you can ask the questions in the Q&A box beneath at the bottom of your screen. I would like to introduce the judges from the court, Judge Chung and Judge Akane. His Excellency, Judge Chung, I will start with you, is from the Republic of Korea and was elected as an ICC judge in 2015 for a term of 9 years. Prior to the ICC, Judge Chung served as a UN judge into the extraordinary chambers in the courts of Cambodia in Phnom Penh. Before that, Judge Chung served in several positions as a judge in the Republic of Korea. Judge Chung will go into the question of criminal justice at national courts, UN special tribunals, and the ICC. Judge Akane will follow after Judge Chung, and Her Excellency Judge Akane joined the ICC in 2018. Prior to joining the ICC, Judge Akane served as Japanese ambassador to the International Judicial Cooperation. Before, she served inter alia as a prosecutor in Japan. Judge Akane also acquired experience in academia as professor of criminal justice practice at several universities in Japan. Judge Akane will focus her introduction on the role of the ICC to promote the rule of law in the domestic, regional, and global levels. First of all, we'll go to Judge Chung. Judge Chung, you have the floor.
Thank you very much, Madam Excellency. And thank you very much, all the participants of this event. I'm also happy to join this event again and fifth time. And right now we have the presentation, and I hope all the participants can watch my presentation file clearly. Next slide, please. So sovereignty of independent state shall be respected and protected. So even UN Charter is protecting the sovereignty of independent state under the principle of the sovereign equality. And exercising criminal jurisdiction is one of the most important parts of sovereignty. And so in principle, all those crimes, alleged crimes, or all those criminal cases should be investigated, prosecuted, and tried at national court through the national judicial system. I believe most of you are already practice as a lawyer, or in the near future, you may be the lawyers or study further as a professor. And most important role of a legal professional is to strengthen your own judicial system, your national court, so that all the people in your country can protect their freedom, human rights through your own judicial system, before the judges of your national court. That's the most important role of all the lawyers, legal professionals, and I hope, and I'm sure that all of you may do such role in the near future. But still, some countries may have difficulties in investigating, prosecuting, trying their own crimes, especially international crimes, through their own systems. And sometimes some countries may face situations where they cannot tackle those international crimes through their own system. In that case, United Nations, especially Security Council, can intervene or override the national judicial system in accordance with Chapter 7, especially Article 39 and 41 as part of non-armed forces measures. Next slide, please. And that's why the UN has involved in establishment of some UN special tribunals, such as ICTY, ICTR, SCSL, and ECCC, ECCC. So the first two, the ICTY for former Yugo and ICTR for Rwanda, was established by the UN Security Council resolution, again, according to the Chapter 7. And those two are 100% UN court, only composed by UN judges. And SCSL for Sierra Leone, also based on the Security Council resolution, but the difference is that this was established by the agreement between the UN and the Sierra Leone government. So still based on Security Council resolution, but on top of that, this court was established by the agreement between UN and Sierra Leone government. And ECCC for Cambodia is also established by the agreement between the UN and the Cambodian government. But at this time, UN come to realize that when it comes to agreement, because agreement is not kind of overriding power or some intervening based on Chapter 7. So UN thought that when it comes to agreement, it's not necessary anymore, Security Council resolution, because this is not part of Chapter 7 approach, because this is agreement. So even unlike SCSL, at this time, UN reached agreement not based on Security Council resolution, but General Assembly resolution. So this court was established without the application of Chapter 7, just a General Assembly resolution and the agreement between UN and Cambodian government. So UN can still establish this kind of international UN special tribunals based on their own authority. So in many news articles, you may have read many people looking at the possibility of what is called hybrid court regarding Ukraine situation. Hybrid court regarding Ukraine situation. My understanding is that those people who are looking at the possibility of a hybrid court for Ukraine situation is considering this example of ECCC, ECCC, because this court can be established without the Security Council resolution. This can be established with only General Assembly resolution. That's why I believe many people are looking at the possibility of establishing some new hybrid court with the involvement of United Nations for the Ukraine situation. Next slide, please. Now we have also Rome Statute and International Criminal Court. Rome Statute is the founding treaty of the International Criminal Court. So like other international organizations, or only member states or state parties are bound by this Rome Statute. Currently, we have 123 state parties, and we are dealing with only what is called international crimes, such as crime of genocide, crimes against humanity, war crimes, and the crime of aggression. Next slide, please. And as I mentioned, only state party, member state of the Rome Statute, we can exercise jurisdiction. And some states are not state party, but if they make declaration, those accepting states can be also subject to this Rome Statute. On top of that, we cannot tackle state parties at any time we want. We cannot do that. Our jurisdiction over state parties is also limited by this principle of complementarity in Rome Statute Article 1. So only if state parties, member states, do not carry out investigation or trial genuinely, then ICC can tackle those situations. Next slide, please. So please keep that in mind, that if we want to exercise our jurisdiction to state parties, all those crimes should be committed on the territory of the state party or member state. Something had happened or alleged crimes should be committed on the territory of the state parties, as provided in Rome Statute 12(2)(a). Please remember this idea of territory. This is very important part for my following presentation. So something should happen in the territory of state party. Then we can intervene, or then we can exercise jurisdiction over state parties. Next slide, please. But we have one official exception to exercise our jurisdiction over non-state party. That is provided in Article 13b, and that is if the UN Security Council refer non-state party situation to the ICC, and then we can exercise our jurisdiction. Actually, this is not the power of ICC. This is still power of the Security Council based on Chapter 7, but that is engaged in as part of ICC jurisdiction. So UN, that means UN Security Council, as I mentioned, they still establish 100% UN Special Tribunal, or based on the agreement, they still establish hybrid court based on their Security Council resolution. And on top of these two, now Security Council can refer the situation to the ICC. So now Security Council enjoy this kind of new option based on this Rome Statute and the International Criminal Court. Until now, we have two such situations, Sudan and Libya. So those two are not state party, member state of ICC, but thanks to Security Council resolution and their referral, now we can exercise our jurisdiction over these two non-state party situations. So if you are interested in starting this non-state party situation referred to by Security Council, I strongly recommend you to this decision issued by Pretrial Chamber 2 in 2017. This decision includes all possible legal issues arising from non-state party situation referred to by Security Council. So if you read this decision, and this decision is also confirmed by Appeal Chamber. So this still remains as one of the most important and strong jurisprudence of this court. And you may clearly understand all those legal issues arising from the non-state party situation referred to by Security Council. So we have only two. Keep in your mind that we have only two of a non-state party situation referred to by Security Council. Then now, I believe most of you have some question, some very important question. As I said, we have only two, Sudan, Libya. But as you have read in many news articles, we have more non-state party issues of the ICC, such as Myanmar, US, and Russia, and Israel. And these situations are covering most of the news articles regarding the ICC. Then how ICC have tackled these non-state parties, such as Myanmar, Israel, US, and Russia? On what legal grounds ICC has done? I will explain this to you. Next slide, please. When it comes to Myanmar issue, Myanmar is not state party, But Bangladesh, neighboring country of Myanmar, is a state party. And in its decision of Pretrial Chamber 1 in 2018, it ruled that the alleged crime of deportation committed in the territory of Myanmar, not non-member state, at least one element of a crime. So crossing border crossing of deportation took place on the territory of a state party, which is Bangladesh. So Myanmar is not state party, and Bangladesh is state party, and one element of a crime of deportation took place in the territory of a state party, and that's why ICC, especially prosecution, can exercise jurisdiction, can carry out investigation over crimes mostly took place in Myanmar, because this at least one element of a crime took place in the territory of a state party. And regarding Afghanistan situation, same approach was taken. So many alleged crimes was committed on the territory of a state party, this time Afghanistan. So the ICC can exercise jurisdiction. Prosecution can start the investigation irrespective of the nationality of the offenders, because something happened in the territory of the state party. Next slide, please. And regarding Palestine situation, also same approach. Something happened, some alleged crimes happened in the territory of Palestine. That's why we can start the investigation, or ICC can exercise jurisdiction regardless of nationality of the offenders. But in this case, they need to verify first whether Gaza and West Bank still part of Palestine. And based on UN resolution, the pretrial chamber 1 ruled that those two regions are still part of Palestine territory. And that's why the ICC prosecution can start investigation over alleged crimes committed in those two regions, which are still part of Palestine territory. Next slide, please. And regarding Georgia situation, also same approach was taken. Some alleged crimes was committed in the territory of Georgia, which is South Ossetia. And that's why they could rule that prosecution start investigation. And even last year, they issued the first arrest warrant against non-member state national who is Russian. It happened in 2022, June. So now the pretrial chamber forward one step further. So not only starting investigation, but also arrest warrant was issued against non-member states national. And next slide, please. And most recently, regarding Ukraine situation, the ICC issued arrest warrant again against non-member state national, who are two Russians this time. So by expanding our jurisdiction, the ICC has tackled non-state party situation, non-state party issues, which is very much closely related to the state party. So we cannot tackle any non-state party issues, but if those non-state party issue is closely related to the state parties, especially something happened in the territory of state parties, ICC has tackled those non-state party related situation of state parties. This has been done until now by the pretrial chambers. But can we then go one step further? Can we start the real trial against those non-state party national? We do not have answer yet. We do not have any case law or jurisprudence regarding whether we can start trial against non-state party national without Security Council resolution as required by 13B or Chapter 7 of UN Charter. We have done that without Security Council resolution for starting investigation or for issuing arrest warrant. But can we do further, start trial without the Security Council resolution? We do not have answer on this issue yet. So I'm also waiting for the answers of our colleagues of pretrial chamber on this issue, whether we can start a trial or we can start the pretrial stage confirmation process without Security Council resolution or not. I'm also waiting for that. So let's wait and see what the next level of our judges answer to this question. Thank you very much. Madam Excellency, microphone, please. Madam Excellency, microphone.
Excuse me. Thank you, Judge Chung. It was a very interesting presentation, especially the non-state party situation. I'm sure there will be lots of questions. Please put your questions in the chat and not raising your hand. But before going to the questions, I would like to give the floor to Judge Akane.
Thank you for your kind introduction, Ambassador Nora Stefire. And dear participants, ladies and gentlemen, good morning and good afternoon. I'd like to show my slide. And I also thank Judge Chung for his very interesting intervention. In my intervention, I'd like to focus on the role of the ICC to promote the rule of law in the domestic, regional, and global levels. I'd like to discuss it only from three aspects of the ICC's role to promote the rule of law, such as from the aspect legitimacy, credibility, and the practices based on my experience as a judge of the ICC. Yes. First aspect, legitimacy of the court, come from the Rome Statute system, including its organizational settings. Please look at the slide. I show the excerpts of the preamble of the Rome Statute, which relates to its missions and ultimate aim of the ICC. These excerpts clearly show the profound mission of the ICC and the determined wish to achieve its aim, that is to end to impunity with the state parties. Next slide, please. Please take a look at the slide, which illustrates the composition of the state parties of the ICC. I will come back to this slide a few minutes later. Please. Yes, thank you. I'm going to touch upon the basic structure of the organs as well as the functions of those which are determined by the statute. Three main organs are judiciary, office of the prosecutor, and the registry. The office of the prosecutor is completely separate from the judiciary on the matters of personnel and other administrative functions, and on the major functions from the preliminary examination to the investigation and prosecution. The judiciary does not interfere with the prosecutor's decision when and which situation they would initiate preliminary examination, for example. On the other hand, the judiciary, which consists of pretrial, trial, and appeals divisions, has the power to supervise the prosecutor's performances by way of issuing orders and decisions, and to preside the judicial proceedings after a suspect is surrendered to the court, whether to issue an arrest warrant based upon the prosecutor's request or to confirm the charges upon the prosecutor's request, for example, are within such judicial power. To render the judgment and sentence is also one of them. Legal system of the Rome Statutes reflects major systems in the world, such as common law and continental or civil law systems, but it does not mean that the system is a copy of some existing legal system in the world, including some international criminal tribunals. In this sense, the Rome Statute system is very unique and comprehensive one without any other previous examples. At the same time, it involves very complicated proceedings, such as confirmation procedure under the adversarial model, so that it would protect the human rights of everyone involved in the proceeding, while it is also intended to promote expeditiousness. In my view, in short, This structure and procedure complex under the Rome Statute would be also the key for securing the legitimacy of the court and the manifestation of the rule of law. Please back to the slide 3 of the map. Yes, thank you. I will move on to the second aspect, that is credibility of the court. Diversity of the personnel, including judges and staff, is one of the factors of the credibility, I believe. I will explain. Before I touch upon the diversity, I may say, as a premise of that, the Rome Statute system proposed to achieve a worldwide jurisdiction. In other words, aim to universality. And it is possible if it is joined by all the states on the globe. Unfortunately, we cannot achieve that yet. To date, the state parties of the Rome Statute have reached to 123, 2/3 of the countries on the globe, while the representation is low in Asia and Pacific region, as this map shows, and also Chung and our president also touched upon this matter. Please move to the slide 5. Yes, thank you. I'd like to touch upon the election of the judges. Please look at the slide. Judges of the ICC are requested these kind of qualifications, but at the same time, every judge should be elected from different country, and there are some requirements on the gender and region so that the diversity is maintained. Next slide, please. Currently, 18 judges of the court, 9 women and 9 men, come from 18 countries from 5 regions, namely 1 Africa, 2 Asia and Pacific, 3 Latin America, 4 East Europe, and 5 West Europe and others. Staff of the ICC are coming from nearly 100 countries in the world. The fact that the diversity of the judges and staff may reflect the diversity of the domestic and regional legal experiences, and the ICC's experiences would affect to the state parties where they originally come from. I believe such informal interactions between the staff of their own countries always happen. At the same time, diversity of the composition in human resource strongly assists the principle and the mechanism put by the statute, including independence, impartiality, and fairness. And it works to promote the credibility of the court, as it is called truly an international court. Due to the dynamism of the diversity, the court may function only when it follows the proceedings which are given by the Rome Statute framework. That may also be a part of the rule of law that Rome Statute system aims to achieve. Next slide, please. I'm going to move on the third aspect, that is ICC's practice based on my experience as a judge of the ICC. That is related to the actions to promote the rule of law. As I said, partly because of the diversity, during our judicial work and the court proceedings at the ICC, our only guidance is the Rome Statute and its fundamental principles it upholds, and that must be consistent with internationally recognized human rights, instead of applying our own domestic laws and others. I must admit that our decision-making process is not usually very easy due to the complicated proceedings where the chamber is frequently requested to seek the parties and participants' submissions or views before rendering our decisions. Nevertheless, that could bring us also very fruitful outcomes, which could be the most impartial and objective ones over the lengthy and candid discussions, which bridge the different views among the judges and the parties and participants. In addition, the trial proceedings and the decisions of the ICC are broadly announced to the public for the purpose of transparency, and that may also show the accountability of our decisions. They are implemented on the rule of law principle. I may say that such proceedings are also supported by the players out of the court, such as witnesses, victims, defense counsel, as well as the accused. I cannot tell you by showing the concrete case, but there are witnesses who testified in front of the court actually realized the rule of law through their experiences in front of the judges. Same could be said even to the accused of the ICC. Some of them actually expressed such positive impressions during the hearings. I have accumulated such kind of experiences during the procedures of pretrial and trial proceedings over 5 years. Next slide, please. I'll briefly touch upon the outreach activities of the court to the affected community, which may assist the local people to promote the rule of law. Judicial work by judges is basically directed to the actual cases and persons who are involved in. So judges do not deal with general public apart from the case. However, I may introduce the ICC's local staff's efforts working for the ICC's field offices to relate the individual cases to the local people of its origin. The local staff organize face-to-face sessions in some local areas where they know victims are. They inform the participants about the decision of the judges or any relevant information related to the proceedings. Next slide, please. Outreach events are to explain the basic information of the ICC's activities based on the ongoing hearings. In a remote city, for example, people were amazed to see hearings. It gives credibility to the proceeding because they can see it. They could watch the battle between each party before the judges who made decisions upon their arguments. In many countries where the ICC work, the national justice is not perceived as independent or does not work. The audience can see how justice should work. What is fair? What is a fair trial? Showing the images of the hearings also assists the staff to showcase the fact that the ICC is independent and impartial. Next slide, please. The reactions from the audience vary in accordance with their previous knowledge and concerns. I can introduce some questions which the participants ask to the local staff. For example, could the evidence put forward by the defense of an accused be elements in his favor? Another question is, how are the legal representatives of victims designated? next question is how to be assured that the victims are real victims. Next question is, does compensation for acquittal, suspects or accused exist at the ICC? The last question, for example, why is the process of the ICC is so slow? They are all good questions and good reactions of the outcome of the outreach. Next slide, please. I believe I could show some examples which may give possible impacts on the regional and domestic criminal justice field the ICC could bring about. And those people who have been involved in the ICC's proceedings or the outreach activities must feel that the rule of law could be the key for developing the criminal justice system even in their own domestic field. Thus, I'd like to make an invitation to the states in Asia and Pacific region to commit themselves to the Rome Statute system. It is easily inferred that the role of the ICC might be different among Asia Pacific region and Africa, based on their respective histories and legal experiences. However, to be exposed in a really international criminal proceedings occurring at the ICC may impact on domestic and regional systems or the implementations in the region, and vice versa. It means that ICC also could learn from the domestic and regional practices and legal experiences. Thus, I would like to invite the states to commit themselves to the Rome Statute system and to promote the rule of law hand in hand with the ICC at the domestic, regional, and international level. Next slide, please.
Oh, Judge Akane, sorry to
Thank you for your attention. Thank you.
Okay. Thank you, Judge Akane. Thank you very much for your introduction, and I think that was very useful. We still have time for some questions. I take out one question from Ziad to either of the judges. How does the ICC enforce their decisions? Judge Chung, can you?
Okay, because I already seen questions regarding my presentation, so I will answer all possible questions using this opportunity. For this first one, the enforcement of our judgment, if we have some judgment, conviction judgment, and if that is confirmed by appeal chamber, then we can request the state party concerned, the state of the accused person, to put the accused person in the prison of that member state concerned. That's the principle. But if that cannot be done by the member state of the accused person national, then we can request other state parties based on the agreement between ICC and those specific state party to accommodate those accused person in the prison of the member state. So principle is sending back to those people to their own country. But if that is not available, then we can request other member states to do some, to use their prison for these accused persons. That's what we do at the court. And regarding my presentation, I could see some misunderstanding of my question. What I mentioned during my presentation, whether we still need Security Council resolution to proceed further of a trial case or not. This is not my position. I never said that this is my position, that we need the Security Council resolution. But I just raise a question whether we need additionally the Security Council resolution to proceed further of a trial against the non-state party national, because this has been continuously raised by those non-state parties saying that ICC cannot exercise jurisdiction against non-state party national without Security Council resolution. This was always argued by those non-state parties. That's why we need to give an answer to this question. But this is not my position. Please make sure that this is not position, but I raise this question whether we need a Security Council resolution or not to proceed further to the case or confirmation process without the Security Council resolution. That is just raising question. And that's why I mentioned that we need to wait and see what the answers from the court should be in the near future. And regarding hybrid court from UN, right, the General Assembly resolution is clearly different from Security Council resolution. But when it comes to agreement, not the Chapter 7 overriding power of UN, but just agreement, this can be reached by the agreement between UN and specific country on specific issue. This special court, whatever it would be, this court cannot cover all national criminal justice system. This is very much limited. That's why we call it special court. This is only a specific situation, but agreement can be done without the Security Council resolution. That's why UN could establish a hybrid court based on agreement without Security Council resolution, but by General Assembly resolution, because this is just agreement and this is not overriding power based on Chapter 7. And any issue you want to raise before ICC, you need to send information to the prosecution. Recently, the prosecution upgraded its system of receiving information from the whole world. So if you want to tackle any specific situation in your country, which is not well handled by your own system, you can send such information before the prosecution. You can find that route in our website. So send any kind of information if you want to raise before the ICC. Thank you very much.
Thank you, Judge Chung. Judge Akane, would you like to add?
Yes, thank you very much. Not to the questions in concern, but related to that question, there is another question about the enforcement of the arrest warrant. It is not by the ICC's staff, but always we have to ask the state parties and other states to carry out the actual arrest and ask them to surrender the arrested person to the court. That is why we need the cooperation with the state parties and also sometimes by non-state parties as well. We don't have any own our police force to go there and arrest them. Thank you.
Thank you, Judge Akane. Yeah, I think it's all very interesting, and also from both your interventions, it makes clear that it is a complex legal system. So I'm very happy that you made those presentations. I think we still have time for one question. Oh, sorry, this is my voicemail. Let me see. Yeah, I still have question. Well, we already discussed this, but maybe as a last question, how are warrants of arrest issued by the ICC to be carried out?
Yeah, that is a question I intended to answer. the arrest warrant itself is issued by the pretrial chamber, which is designated to the situation based on the evidence submitted by the prosecutor. But carry out of the arrest warrant, which is issued, is up to the state parties or the non-state parties, where the suspect may be there.
Right, that's correct. So arrest warrant can be achieved through the cooperation of most of the state parties. So, as I mentioned, regarding Sudan situation, we issued some decision which is dealing with all kind of possible legal issue arising a non-state party situation referred to by Security Council. And if you read that decision, you can find all those details how the state parties need to cooperate in terms of enforcing this arrest warrant. That's why I also recommend you to read that decision during my presentation. So maybe you can find many answers in this decision as well. And I also see many questions regarding specific situation of the participants, whether this specific situation can be handled and how can it be done. But unfortunately, we judges cannot answer on those specific situations. So that's why I just generally mentioned the answer that sending any kind of information before the prosecution. And if the prosecution believes that such information constitutes enough the background of starting investigation at the ICC, and they may start soon. But regarding Philippine situation, if I may add, Philippines used to be the state party. So, and that's why we judges already ruled that all those alleged crimes happened in Philippines are still under our jurisdiction. So even it's not state party now, because it used to be the state party of the ICC, and we found that we can still exercise our jurisdiction over those alleged crimes, and that's why we are still tackling the Philippine situation, and that's the some exception of the situation at the court. Thank you very much.
Okay, thank you both judges. I think that was very helpful, and I would like to thank both excellencies for their presentation and answering of the questions. We are right on time. I would like to close down this session and thank you again. If there would be questions still not answered, but I saw a lot of questions were already dealt with in the presentation, so I would like for the participants that they read again or listen again, and then you have answers to your questions. Thank you very much, all of you, and I'll give back the floor to Maya.
Thank you, Madam Excellency.
Thank you very much.
I would also like to thank our judges, Judge Chung and Judge Akane, for their insightful interventions, as well as Ambassador Stehauer for her contribution. Allow me now to introduce you to Ms. Hyu-Sun Kim, the moderator of our second session. Kim, the floor is yours.
Thank you, Maya. Good morning and good afternoon. I'm Hyun-Sun Kim. I'm here at the ICC working as a program officer. It is indeed my great privilege and honor to be here as a moderator of the session 2. Here we will spend half an hour to talk about stories and discussion with our ICC staff from the Asia Pacific background. So we're certainly very excited to hear more about the real stories happening on the ground. What is it like to work at the court, and how the justice actually happens on the scene. So I'm sure the audience here will share the similar background, and they're very curious to know what daily life is as an ICC staff. And it is something we don't get to hear that often. So without further ado, I would quickly, briefly introduce our three panelists with very interesting background in the Asia Pacific context. In fact, we also these three colleagues also work at the three different organs, so they'll certainly share different elements of the work at the court. So first we have Pubudu Sidnandan. Please correct me if I'm wrong. He worked as a trial lawyer, and he's from Sri Lanka. He worked at the Office of the Prosecutor. And we also have Ms. Jayan Kim. She is from Korea, and she worked as an associate legal officer from the chambers at the court. And lastly, we have Mr. Michael Hirsch. He worked as a legal officer in the Office of the Public Counsel for the defense. And prior to, just to share with you a little bit of background of our panelists, Pubudu, before joining at the court, he worked as the officer at the UN Tribunal for Rwanda. And Jayan Kim, she worked at the Supreme Court of Korea and National Court of Administration as a legal research member. And for Michael, before he joined at the court, he worked at for the prosecution, judges, and the defense at the 4 different international tribunals. So they certainly can bring rich story using their background before the court or now here at the court. So I'd like to open the floor let me just quickly jumpstart by diving into the topic that brought us here together, which was opened by Maya, which is access to justice and making impact to justice. So this is in fact the questions for all 3 of you, but I first want to give the floor to Pubudu, because I presume your work as a trial lawyer involves going to the courtroom and litigate cases, stuff that we can expect. But we know that most of the work happens here at the court in The Hague, in the Netherlands, which is quite far from the field. And can you give us a more lively picture? What is it like? And do you come across any moments that you feel that you're making impact to justice on the ground?
Thank you so much. Can you hear me?
Yes, we can hear you.
Fantastic. Yes, absolutely. You know, of course, when you visit the ICC or when you watch the live stream on the internet, you mostly see the scenes in the courtroom. But as you can imagine, there's a lot going on in the background, and there's a lot that goes on before anyone even comes to the courtroom. So before this, for many years, we will be, or at least many months, we will be investigating cases. We'll be going to the field. We'll be talking to various types of witnesses, hearing their stories, etc. And then also at the before going to court in a number of trials, you would, for example, sit down with witnesses in a witness preparation sessions and talk to them as well. And then this, it is this sort of process of engagement that then culminates in that moment when you see people in the courtroom, see a witness in the courtroom. And that human engagement, I think, is one of the places where I feel like I have at least a small impact, because I get to listen to the story of people who have suffered during conflicts, and give them a chance to talk about their experiences. And I feel like at least providing people that opportunity is a hugely important thing.
Thank you, Pubudu. That is certainly a very interesting story that we don't get to know very often. And I'd like to turn the floor to Jayan, who worked as a legal officer at the chamber, because you work very closely with the judges, providing legal advices. So you can certainly add what Pubudu has said. So in your capacity, do you also have some stories to share or similar memories that you can share?
Thank you, Jensen. I also agree a lot with Pubudu had said, and because I work in the chamber, it is very important that we have a fair trial. So we listen to both sides of the story, and knowing that their stories had never been heard makes you realize how important the court is. And another point I want to make about relating to access to justice is how much the court is trying to make as much public as possible. I think majority of the decisions and filings are available to the public. And if there is confidential or sensitive information, that part will be redacted, but it will still be available as public redacted version. And also this has been mentioned by Pubudu, and the ICC offers court streaming. So anyone who is interested in the trial, you can go to the ICC homepage and see the trial yourself. So as long as you have internet connection, you can see what is happening in the trial.
Thank you, Diane. The same question definitely goes to Michael, who works on the other side of the court, if I may say, because you work for the Public Counsel for Defense. So defense in itself is in a way familiar, but it could be quite unique in the international context. So maybe it'll be very helpful if you share a bit about what you do and then how you feel impact to justice.
Thank you, Kim. Yes, the defense office at the ICC is quite unique, and it's a bit different to how it works in domestic systems. So the lawyers that you see that are representing the accused directly in the courtroom, they tend to be external lawyers to the ICC. They have to be external because they have to be able to take instructions from their clients and not the court. Now, I'm a part of the registry administratively, but my office, the OPCD, is wholly independent in the way that it functions. And it is under the registry administratively because the registrar has responsibilities to ensure that those defense counsel, those external defense counsel, can perform their jobs effectively. So my role is to provide legal advice and support to those defense counsel. And the reason this is necessary is because the prosecution also has lots of internal offices that provide support to all their trial lawyers. And the judges thought it's a good idea to make sure that the defense have access to the same types of resources from in-house counsel and in-house lawyers, to make sure that the equality of arms can be respected. And the idea is that the better that the defense counsel do their job, the better the arguments are before the judges and better the decisions that the judges can make, which is make sure that the end outcome, that everyone can have confidence in the end outcome of the proceedings.
Thank you, Michael. Yeah, it is very clear that for the equality of arm and fair trial, and also because of the impact of justice and access to justice, it is very important to have the Office of the Public Counsel for Defense here at the ICC. So now it can lead to our next question. What are the differences or similarities between because I want to ask more about to Michael, because you touch upon a little bit about the differences between international and domestic of the public defense. In your experience, because you certainly bring very interesting background. I know that you're half Indonesian and half German, but you studied in the UK and elsewhere. So in your background experience, what background was certainly helpful in building up your career, and then what do you think would be helpful for our audience if they can study or yeah.
Thank you, Kim. Yes, thank you for highlighting. I'm half Indonesian, half German, and I grew up partly in Indonesia, partly in Europe, mostly in the UK. And before the ICC, I was also in various defense teams. And maybe I'll highlight perhaps a cultural background that has been particularly helpful for me. The teams, they have to be very diverse because you have a combination of a situation country, and you need to have lawyers from the situation country, but you also need to have lawyers who maybe have expertise in the laws of the ICC. And there's a smaller group of lawyers who have that kind of expertise. So there have to be a mix of the teams. And speaking on behalf of the people who do have mixed backgrounds, I think we have, quite special and unique abilities to be able to bridge the divide between people from one continent and have to work with other people from another continent. And that is usually the biggest challenge that I find. Everyone comes from a lot of places, and being able to allow people to work harmoniously is a difficult challenge. And people who have those different backgrounds can, I think, provide that bridge. And usually when there are issues between people working from different countries, it tends to be misunderstandings. And I think people in my background are able to sort of allow people from one country to understand the other countries better. So I encourage anyone who does have such a background to not underestimate your abilities. It's not the only way for you to be able to do this role. I think everyone can do it. I think everyone can work together well, but I think it's a unique sort of innate ability that people with multiple backgrounds can have.
Thank you, Michael. It is certainly interesting. You bring those two different pillars together and they work as bridges to make sure the external teams can work better at the court. And it let me think naturally Pubudu's background, because you explained to me that you spent most of your youth in Sri Lanka and you had some education there, but you also had some educational background here in European universities, if I'm not wrong. So maybe you can add what Michael has said in terms of using your background and how it has helped you to excel here at the court.
Thanks. That was a fascinating answer by Michael, and I couldn't agree more. Yes, so I've also had quite a hybrid upbringing. I grew up in Sri Lanka, and also my mother is from the Sinhalese community and my father is from the Tamil community. So even in Sri Lanka, there was quite an experience of hybridity. But then also, I think when you grow up in the East and then let's say you go to university in the West, there's also an interesting mixing of experiences and cultures, which I found, just like Michael, tremendously helpful at the ICC, because it helps you allow for, or at least makes you already prepared for the kinds of misunderstandings that can pop up, and also helps you, I think, make full use of the tremendous diversity that we have. One thing I really love about the ICC is that I can be in the cafeteria or in a meeting, look around and count maybe 20 countries in that represented in that room, or 30 countries or 40 countries. So I think being from Asia and then coming to the ICC has really helped me deal with diversity and also helped me use emotional intelligence and social intelligence, which I think are tremendously important. Of course, technical skills are very important, but I think these other cultural sensitivities and capacities are tremendously useful, not just for working with colleagues, but also I think, for example, when working with witnesses. When someone from a situation country comes to the ICC and I can see that they're nervous because it's a new experience, I can see that they are trying to adjust to this new environment. I have had that experience, so it is easier to build that connection.
Thanks a lot, Pubudu, for a fantastic answer. Now we're, of course, very curious about what Jayan would want to say, because we just touched upon the issue of cultural background. And I want to ask Jayan more about the educational background, because I had the interesting question that just popped up from our Korean audience. He was wondering whether there's a preference in terms of pursuing the legal education. Would it be better if I study in Korea or in the US or in European country would be helpful to work at the ICC, for example? And I know certainly you have both background in Korea and in the US, so it'll put you in a very natural position to answer these questions and a bit of background as well.
Thank you for the question, Yunsun. As you said, I studied in Korea for my bachelor's, and I studied in the US for my LLM, and I'm still pursuing my PhD in law in Korea. So I have both the civil law and common law education background. And I believe it does help knowing the two different legal systems, because the Rome Statute actually, incorporates both systems, and having that different view will be helpful in carrying out the work. But I think it's not the necessary part, because I think legal system, although it is maybe different, we are dealing with a lot of procedural issues, and I think both sides of the legal system could bring different views. So I think whether it's in a different country or just one country, I think if you know the law and the rules, I think it will be, it makes you qualified to work here. And also what I felt from working from the ICC is that I came from a country that is very far away from here, and also far away from the places where the alleged crimes occurred. But what surprised me was that the more I learned about the case and through the testimonies, I found that there are so many similarities that we share. And although we look different and may speak different languages, in the essence, we are same. We share the same values, which is the humanity. And having this connection, I realize it is not just about someone else on the other side of the world, but it is just us, and it is our own humanity that we are trying to protect. And I think it is what makes the ICC so special.
Thank you, Jayan. It is very inspiring to hear what you have felt along the way by working close to those affected from the crimes. And you touch upon a little bit of trace or knowledge that people can bring using a different background. And I want to delve into more on the quality aspect to work at the court, because what qualities, for example, do we believe the professional from Asia Pacific region, or not necessarily Asia, but other background can bring? I want to turn to Michael again, because I know he works particularly a lot with external teams, as you said, with many different countries. And is that the only way that that people can contribute as an external teams, or is there any other ways? Or if so, what would be sort of like a map for them to already start contributing using their experiences or as a legal professional in their own countries?
Thank you, Kim. Yes, there are, there's lots of ways, but the two main ways I'm going to talk about are this being a staff member of the ICC, whether as the prosecution, helping the judges, being in the registry, or even in my office. But there's also the external teams, as I mentioned, and that can include also defense teams, external victims teams, and government counsel, and also witness advisors. And I'm going to talk about the qualities that I'm sure a lot of our participants have today. That will be, I think, very valuable. And that's your own domestic skills and experience and knowledge about your own domestic laws. You may think, okay, the ICC, we deal with international criminal law. And that's important. That's something that you have to be able to know and be skilled in. But having your own domestic skills and experience, you shouldn't underestimate that too. As Judge Hofmański said at the introduction, then there's a lot of influences that come from what you bring as a staff member, as a lawyer, from your own domestic experience to the ICC. The laws of the ICC are still continually being developed. We're quite a new jurisdiction. We're only about 21 years old. And it takes a long time to mature. There's a lot of things that are still haven't been interpreted, that haven't been fully resolved. And I see a lot of these quite complex questions in my office because we tend to get questions that are quite complex that there is no answer to in the Rome Statute. So what happens is, under Article 21 of the Rome Statute, one of the applicable sources of law is general principles. And that can be domestic laws. And for that, we need to have a wide range of people from different backgrounds, so that whenever there's a question of interpretation, we can go to domestic laws and see, okay, how is it done in that country? How is it done in that country? And then therefore, there's naturally a reflection of who are the staff at the time when that decision is made. And in the past, if Asia Pacific is underrepresented, then the laws and principles from the Asia Pacific region will not necessarily translate to the final decision. And then the laws of the ICC will be shaped along a path that is going to diverge a little bit. So that's why it's super important that you bring your own domestic knowledge to the ICC. And I encourage everyone to contribute, whether as a staff member, whether as an external team member, so they can help shape and influence the laws of the ICC to truly reflect all the countries of the world.
Thanks a lot, Michael. I'm learning a lot by listening to what you have said. I didn't know there's this element that you can actually use your domestic legal knowledge, and I'm sure the audience will be interested to hear more about the story later on. And maybe to you, Pubutu, I think you want to complement what Michael has said, because you also have very rich experience before the ICC or in the ICC. You're the longest serving colleague among ourselves. And in your experience, what quality, it doesn't have to be legal knowledge per se, but what qualities can be cherished or desired by working at the court?
Yeah, absolutely. And I'll echo what Michael said. It's absolutely important that you bring your domestic legal knowledge as well. I've seen many examples where brainstorming on a new problem, and you're sitting together with colleagues from different systems, and everyone's throwing out ideas, which they have, for example, gained at least partly from their own system. And then from those, we create solutions, which are often these mixed or hybrid solutions from these various backgrounds. So tremendously important. Yes, so I think when you come, when you apply to the ICC, when you come here for an internship, a VP, a visiting professional position, or a staff position, please do bring your genuine selves. This is not a Eurocentric institution or a Western institution. It's a genuinely global institution. So you have to bring your own genuine self and your own background, and that is tremendously useful. Having said that, I will mention some things that will make your life easier at the ICC. One is learning new languages, So I'm primarily an English speaker, but learning French helped me tremendously to work with other colleagues, understand certain things. And in the same way, if you're primarily a French speaker, learning English will be hugely useful. And also getting domestic experience in your domestic system, experience, if you can, in other international mechanisms, such as other tribunals. There's the Syria mechanism, there's the Myanmar mechanism. There are all these interesting opportunities that you could try to work at. But having said that, not having that experience is 100% not a barrier. So please don't feel like you need a 5-page CV before you can try to apply here. That's definitely not the case.
Thank you, Pubutu, for very practical advice that I'm sure which the audience was very curious to know. You mentioned again, the domestic legal knowledge, and I'm certainly getting a lot of questions relating to domestic knowledge. And then I will have to turn back to Michael again, because I'm sure most of the audience mostly have a domestic background, and there's sort of a reverse question, whether it is more preferred for the candidates to bring solid legal knowledge before even start their career at the international tribunals, or vice versa. So I'm not sure if you understood the question correctly, but is it actually preferred way for higher managers here to bring solid legal knowledge in whatever jurisdiction, or they actually may prefer those only with the international court experience?
It depends. I mean, for the same reasons that Pubutu and I just mentioned, obviously having good, solid domestic skills and knowledge is a good thing. And for the same, and I agree with Pubutu, but it isn't necessarily a barrier. It really depends. What I would say is, though, that some skills you can only develop really well in domestic law. If you like to go into the courtroom and be an advocate, the kinds of cases we do at the ICC, they're obviously very serious and grave cases. It's unlikely that as a junior lawyer, you're going to develop advocacy skills in the courtroom by only working at the ICC, because you tend to develop those kinds of skills on smaller cases first at a domestic level. And advocacy skills are important if you ever want to join the prosecution or want to work in an external team as counsel. Probably those kinds of skills, advocacy skills, is something you'd have to have a solid background in your domestic level. The kinds of things that you probably can't develop so easily in domestic level is knowledge about international criminal laws and procedures. That's something that you probably have to do some study in before you come to the ICC, or learn about, and maybe develop more when you're at the ICC, either through internships, through visiting professionalships. So it's going to be a blend. You have to know sort of what the knowledge or what the skill is that you're trying to promote and trying to develop. And then you have to find where you can develop that between the domestic level and international level.
Thank you so much, Michael. One question that I had in my pocket for Jayan again, because I know you are the colleague who recently joined here at the court. So maybe you can share some fresh memories or experience in going through the process of joining at the court. And Pupuda mentioned how important the language skill could be. But in your recent experience of joining at the court as a junior professional officer, if you have other tips or advice you can share to the audience here who maybe aspire to join at the court following your past, you can certainly share a few.
Thank you, Jensen. I also fully agree with what Michael and Pupuda had said about the skills that you need to work here. And for me, previously I worked in the judiciary of Korea, and everyone who I worked with was Korean. So the dominant language that we used was Korean. And I don't think I was fully mentally prepared. And because this is my first time working in an international organization, that you have to use English like 100% or French. And I think although I used English in my previous work, I was not fully prepared. And I think a lot of Koreans and maybe in other Asian countries is that we are very afraid of, speaking in another language. And there are a lot of differences in the language itself. But I think a lot of people are prepared for that. And I think we mainly, like Asians, we need to have more courage to speak out in English. And I think the language skills are very important because it is how we, work at the court. And I would really like to emphasize, having good language skills will definitely help in the work.
Thank you, Jayan. We are mostly approaching the end of the session, so we have a few minutes for us to spare. So I want to turn to the floor for the last piece of advice. Those could be inspiring, those could be motivating. Maybe first to you, Michael. Again, if you have last minute of tips that you can share with our colleague who can join in the future.
The advice that I'll leave people with is, and it goes back to the question about what knowledge and skills, what kind of lawyers do we want from domestic experience, from domestic legal systems to come to the ICC, and how can you mold yourself into that kind of lawyer? The cases at the ICC are complex cases. We have hundreds of thousands of pages of evidence and disclosures, lots of crime sites usually, and a lot of witnesses. So if you are a type of person who is organized and is able and capable of dealing with those kinds of cases, and at a domestic level, they tend to be sort of complex frauds, or it doesn't even have to be crime. It can also be corporate law, where you're working in a team together, where you're drafting a lot, where you're dealing with complex cases. They are the types of skills that I would say are very transferable for the ICC on whatever side you are going to be potentially working on. And good advocacy, as I mentioned before, good drafting skills are also the types of skills that we need at the ICC. And all those can be developed through your domestic experience. So you can build a good profile by continuing to work at home, but you need to have a link into the ICC somehow. And again, I mentioned internships are good, visiting professional schemes are good. So you need to develop both sides, and there's a difference there. That's a strategy that I would recommend for people who are considering joining either the list of counsel, joining an external team, or becoming a staff member.
Thank you. I personally very much agree with that strategy because that's the one I had in mind too. Last advice for Pubudu, maybe before we close the session.
Yes, I hope you can hear me. I can see that my internet connection is not great. Yes, I would say if one thing, just to go back to the language issue, one thing that often we do in Asia is that we are afraid of making mistakes, right? Yeah, can you hear me?
We can hear you.
Yeah. And I think we just need to get beyond that. There's nobody judges you if you're learning a new language, for example, or speaking in a new language. It's perfectly fine to make mistakes as you're learning when you're speaking. So really that should not hold you back at all. And also there's many different types of opportunities. The ICC is not just a place for trial lawyers. There's, as you can even see from this gathering, there are multiple different types of opportunities that you can apply for.
Thank you, Pubudu. That concludes our session. We certainly heard a lot of interesting stories and inspiring stories from our colleagues, and we'll talk more about the actual career opportunities by the human resource section. But thank you again for Michael, Jayan, and Pubudu, and thanks a lot for the audience for paying attention.
Thank you, Houston. Many thanks to our panelists for their very interesting presentations. We will now continue with our third and last session, where Ms. Bruna Hofmański will give a presentation on career opportunities. The floor is yours, Bruna.
Hi, Maya. Thank you. Thank you, everyone, for joining. Thank you for giving me the opportunity to talk a little bit more about the career opportunities at the ICC. So I'm going to share my screen. Can you see my presentation?
Yes, we can.
Okay, perfect. So my colleagues have already given you a lot of tips about how is it like to work for the ICC, how to prepare. And I'm here to give you a bit more information, more practical information on how you can contribute to the court's great mandate. So my presentation is about working for justice. So how to work at the ICC, what are the careers offered by the court, and I would also reply to the questions. If you have, please don't hesitate, write in the chat box, and we'll reply to it after the presentation. So as Judge Akane already mentioned, we have 123 state parties to the Rome Statute. 19 of those are Asia Pacific states, so this represents around 15%. And at the ICC, we have more than 900 staff members from more than 100 nationalities. So it's a very multicultural environment. 64 of these staff members are from Asia Pacific states. And we do have a lot of states that are underrepresented at the court, and I'm going to explain this a bit later. So one first thing, we've been mentioning a lot about career opportunities in the legal field at the court, but one thing I would like to highlight is that you don't need to be a lawyer to work at the ICC. The ICC is a tribunal, so of course we have a lot of legal positions available. But if you look at the first graph, you see that the registry, so the secretariat of the court, is the biggest employer. So we have in there a lot of different positions in different fields. So we have a lot of opportunities in the field of administration, security, language. This is just to name a few. And these positions are usually the ones that we have more difficulties finding good qualified candidates, because lawyers, they apply to these positions, and we don't particularly need the legal skills for this, but rather other skills. So this is a first observation I would like to make, but please, if you have a legal background, also we do offer a lot of possibilities, but if you don't, just know that it's also possible to work at the ICC. So I think the ICC as a whole, like as an organization, is a great employer. First, you'll be working for an amazing cause, as the judges have presented before. You heard from other colleagues that it's a very passionate environment and work that we do. As I mentioned, it's also a very international environment. So in case you would be interested to work with people from different cultures in different languages, this is the place. We are part of the UN Common System of Salaries and Entitlements, so we do offer a good compensation package for the staff members. And the court is very focused on staff well-being and engagement. So we do have flexible working arrangements, parental leave, staff development leave, just to name a few of our entitlements. As you can imagine, because of all that, plus the amazing mandate that the court has, we do receive a lot of applications. So I must be honest that it is not easy to get a staff position at the court. However, there are ways that you can prepare yourself. The tips that our colleagues have already done, give to you before, they are very precious, but I'm gonna give you some more information about other things that were also mentioned by Michael, such as the internship and visiting professional program and the junior professional officer program. I would say that these two programs are the best way into the organization. And this is a very good opportunity for you to acquire the experience within the court and the hands-on work that the court is doing. And after that, we see that a lot of interns and visiting professionals, they apply for staff positions and they get positions. This is not a guarantee, but we do have a lot of successful cases. So first of all, what is the difference between an intern and a visiting professional? So interns are candidates or professionals that are in the last years of their bachelor's degree or further in their careers, but they do not have more than 3 years of professional experience. So you need to be really junior in your professional experience to do an internship with the court. Internships are full-time between 3 months and 6 months. Visiting professionals are a bit different, and we are looking for professionals with more experience. So they need to have a bachelor's degree completed and at least 3 years of relevant full-time work experience. Visiting professionals are also for full-time, and the duration is between 1 month and 6 months. So just to give you an example, we have a lot of interns who are just finishing their studies or starting their careers, but for visiting professionals, we receive scholars, judges, and prosecutors from national jurisdictions. They come to the court and they bring with them a background that is very important for the court, but they also learn a lot. So it's a different type of profile that we are looking for the two programs. Some important information also about the internships and visiting professionals. The positions are advertised through the entire year. So at the ICC, we don't have cycles of recruitment, so a specific date in the year where recruitment for these positions are open. Also, when you apply for an internship or a visiting professional at the court, you'll be applying for a specific position. So you're not applying for any internship at the court. You're going to apply to a specific internship, for example, in the immediate office of the prosecutor or the human resources section. So this is also important to know. Most positions of internship and visiting professional at the court are unfortunately unfunded. However, we do have funding offered by 2 different programs. So one of them is the Trust Fund for interns and visiting professionals from developing countries. So if you're from a state party that is a developing country, and here I included 3 different examples in the Asia Pacific region, you can apply for these positions. These positions will be advertised in the court's website as funded position. We also have visiting professional positions funded by the European Commission grant. And these are 8 positions that we fund every year. They are in the legal field, and they are also funded. So this is still not funding 100% of the positions, but we are fundraising more and more. State parties, staff members, judges are contributing to this trust fund, and we are able to fund more and more interns and visiting professionals every year. Now, moving to the Junior Professional Officer or JPO program. This program comes from the UN at the ICC, is quite recent and is based on bilateral agreements between the court and donor countries. Whereas JPOs are recruited as staff members at the P2 level, and all the costs are fully funded by the donor country. So JPOs cannot be older than 32 years of age when applying, and they are usually nationals of donor countries. But some of these countries, they do also accept to fund JPOs from developing countries. The duration of a JPO program is between 1 and 3 years. And currently we have 7 countries participating in the JPO scheme, and 2 of them are from Asia Pacific, so Japan and Korea. How to apply? We do have a website where you can create a profile, and once you create this profile, you can apply to different positions. We don't accept CVs or applications by email or post. So if you want to see the career opportunities currently open, please, I would invite you to go to our website and check. This is what it looks like, a little bit the page. You can filter by internships or visiting professionals or staff positions. So everything you need will be there. One question I receive a lot is, what qualifications do I need? And this has already been kind of covered by Pubudu, by Michael and Jayan. But in any case, this varies a lot. If you're applying for an internship with the Office of the Prosecutor, you will need a different set of skills than for an internship with the Human Resources section. So that's why we have a job description for every internship or visiting professional opportunity. And this is what it looks like. So there you have all the required qualification in terms of education, experience, languages, and also a small description of the duties and responsibilities and the organizational context. So in which office you're gonna work and what that office has as a mission. Judge Akane has also already mentioned that the court is an international institution, and one of our goals is universality. So career opportunities are open to nationals of all countries, state parties or not. However, having said that, we do have state parties that are underrepresented in our staff, and this is a very important issue for the court. And we are trying to attract more candidates from these nationalities. So in case you are from one of these nationalities, we would encourage you to apply for positions. This is considered at the time of shortlisting, so in the beginning of the recruitment, but also at the time of appointment when the final decision is made. And this is also considered in the internship and visiting professional programs. So Japan and Korea are the biggest underrepresented countries, one of the biggest at the court, Japan being the greatest one. And we do have a full list of nationalities that are underrepresented. You can find them on our website. Some of the efforts that we've been taking to improve the geographical representation at the court is advertising all the positions on social media platforms. So the best way to follow the career opportunities at the ICC is through LinkedIn. So we'll have in the next page a link to our LinkedIn page, and I would invite you to follow us, and then you will be updated every time we have a new opportunity coming up. The JPO scheme is also used for geographical representation purposes, since we have Japan and Korea being part of it. The internship and visiting professional as well. We've been trying to engage more and more with universities in the Asia Pacific region, especially in countries that are under and non-represented at the court. And we do participate in a lot of career events to promote the court as well, this being one of them. But in July, the Human Resources section will also attend a career fair in Korea. So these are just some of the efforts, but if you want to know more, you can always get in contact with us as well. Another priority for the court is gender balance. So we do encourage female candidates to apply to positions at the court, especially senior level positions. And we are part of the International Gender Champions Network. So I would invite you to follow us on LinkedIn. And in the next page, I have our email address if you want to contact us to know more about staff positions, internships, visiting professionals, or JPO. Now, this is the end of my presentation. Thank you very much. I imagine you have some questions, so I'm gonna open my my chat box. Okay, I see there are some questions here. So can I work remotely as an intern or visiting professional in my home country? This is a very interesting question. So interns and visiting professionals cannot work from outside the duty station being The Hague, the Netherlands. So this is not possible. The second question is, how do I join the court and VPRS, so the Victims Participation and Reparation section, to help with the victims? So VPRS offers a lot of internship opportunities throughout the year. I'm not sure if currently we have a position open, but if it's not open now, I know in the coming months it will be. So I think if you have the profile for an internship or a visiting professional and you have the availability to take one of these positions at the court, is a great way to start. Interns at VPRS, they have a lot of exposure to the work that the legal officers and the people working there are doing. So I think this would be a great first step in. But from time to time, VPRS also recruits staff members. You need to keep in mind that you'll be competing with people from around the world. So there's a lot of competition, but of course I invite you to apply, especially if you're from one of the under or non-represented countries that I mentioned before. But I would say that the internship is the first step in. And it might be the case that there will be a position in VPRS also part of the JPO scheme. So if you're a Japanese or a Korean, please keep an eye on the JPO opportunities. And it might be the case that there will be a position of associate legal officer within VPRS. Another question regarding the domestic experience before turning to international experience. I see the vacancy announcements only require 1 year LLM to apply to a lawyer position at the ICC. Is it really sufficient? Would it be good for staff at the ICC to have more sufficient background in domestic criminal law before specializing before coming to the ICC? So what you will see in the vacancy announcement is, of course, the minimum requirements. And keep in mind, you'll be competing with people who have much more than what is listed there. So, of course, additional experience is always important. For an internship, no, because we are really looking for candidates in the beginning of their career. So I wouldn't say that if you want an internship, you should gather a lot of experience, otherwise you won't be fit or suitable for this kind of position. But for staff positions, all the experience you can have, especially in the national level, as my colleagues mentioned before, is very valid and will be considered as an asset. Another question, does having an experience of working as a judge in domestic courts for 5 years and above easy the route to the ICC? I think depending on the position, yes. I think it would be a very good experience to have, especially if you're considering working in chambers. We do receive a lot of judges as visiting professionals, and also they can apply for staff positions after their visiting professional is finished. So I think, yes, it's a very good profile to have an experience as a judge, and for positions, especially in chambers, this is very, it might be easier if you have this kind of background to secure a position at the court after, especially if you want to do a visiting professional, or after a visiting professional, if you want to have a staff position. How long the process, the recruitment process take? So this varies quite a lot depending on the position that you're applying. So for internships, we do have recruitments opening for 1 month, and then usually after the deadline for application is passed, the recruitment is done within 1 or 2 months. However, when you are applying for a fixed term position at the court, the process is quite long. So you have first the shortlisting, and then you have the written assessment, interviews, and then a lot of checks and reports that need to be completed. So the process may take up to 1 year. Unfortunately, we are not doing super well keeping the candidates updated on what's happening during the recruitment process. So in case it's taking a bit longer, if it is a fixed term position, it's normal, unfortunately. The next question, how do I know whether my country is underrepresented or even a member state of the ICC? Yes, so to check if your country is a member of the ICC, you can check the ICC website. If you type on Google state parties, Rome Statute, there is a website that will open with a list of all the countries that are part. Now to see if it's an underrepresented or not, we do have reports that are made available at the court's website. So there is a website of the Assembly of State Parties that you can go to, and there is usually a list of countries that are under and non-represented. We used to keep a list on our website, but since the representation of countries change every month according to new staff joining or leaving the court, we couldn't keep up with this work of updating the list. So in order not to keep a list that is not up to date, this has been removed. But you can find this information on the reports that the court provides to the Committee on Budget and Finance every year. So I think this is the end of the questions. So I'll stop sharing my presentation, and I would like to thank you for your participation in this call and encourage you to apply to positions at the court. The court is a great employer and a great place to work. So if you want to contribute to the court's mandate and to international justice, please submit your application and check our career opportunities on our LinkedIn and our website. Thank you.
Thank you very much, Bruna, for your presentation. We still have a few minutes left of our content, so please stay with us. Finally, now I have the pleasure of announcing the closing remarks of the ICC Deputy Prosecutor Khan.
Your Honours, distinguished participants, ladies and gentlemen. Allow me first to express my sincere gratitude for the opportunity to address you today through these closing remarks. My thanks go to my colleagues in the ICC, as well as to the Hague Project Peace and Justice, for organising this forum and granting me the occasion to say a few words. As Deputy Prosecutor and as a proud Fijian national, I attach great value to this interaction, and I hope that participants have found their experiences worthwhile also. The Asia-Pacific region, while underrepresented in the Rome Statute system, is in many ways a global leader in placing the rule of law at the forefront of international advocacy and in our common work to provide protection to those that need it most. The Rome Statute is a child of the East as much as it is a child of the West, the North, or the South. It is built upon the experiences of nations and peoples around the world, whose only desperate desire has been to end fear caused by the atrocities that have harmed our societies for far too long. This law is relevant to all legal practitioners. As Deputy Prosecutor in charge of the Office of the Prosecutor's Pillar A, I am responsible, amongst others, for overseeing the work of the OTP teams for the various Asian situations. That is, the investigations in Afghanistan, Bangladesh, Myanmar, Palestine, as well as the Philippines. Since assuming my function almost 1.5 years ago, I have been struck by the keen interest from interlocutors from all these situations and beyond in the wider Asia-Pacific region, in the work of the ICC, and in accountability and justice more broadly. I have felt enriched by the many meetings I have had so far with state representatives, civil society organizations, victims and affected communities, and others. These exchanges have further reinforced our office's strategic resolve to deepen our engagement and cooperation with all regions and with all states, including those that are not or not yet parties to the Rome Statute. The prosecutor's vision is not the ICC as an apex, sitting above states and national jurisdictions, but as a hub in the field, at the center of common efforts to deliver meaningful accountability based on shared heritage and values underpinning the Rome Statute. The office is increasingly reaching out to the various parts of the world, including the Asia-Pacific region, through missions, enhanced field presence, and innovative partnerships to strengthen exchange. In the coming period, the prosecutor is planning to participate in a number of events in the region and undertake a number of travels, including to Mongolia, Korea, and the Pacific Islands, to foster outreach and to enhance awareness and collaboration. An important drive for the office in this context is to build a new form of dynamic complementarity. Under this approach, the office strives to be a more effective, useful partner for states and organizations. We want to provide you with more information so as to support national justice avenues and proceedings wherever possible. It is our strong preference that justice is delivered with the flag of your own national jurisdictions behind the judge, and not that of the ICC. This commitment to enhance engagement is also reflected in another area where the ICC, and my office in particular, must do much better, ensuring that those who work in our institution reflect the important role that the various regions play in the Rome Statute system. We must ensure your regional perspectives are infused throughout the culture and staffing of the Office of the Prosecutor. It is a key priority for us to address this challenge. We are taking concrete action, amongst others, by seeking to establish in the near future, and in cooperation with the Registry, a new trust fund for geographic diversity. Through this, once established, we will be able to provide financial support to seconded experts from Asian countries and others to increase the exchange of professional experience and expertise between us. We welcome your personal contributions through whatever means available: visits to the court, participation in moot court competitions, in-country trainings, internships, etc., so that we can learn and engage in an effort to support work across the globe to vindicate the rights of survivors. I consider today's exchange as an important step in the further reinforcement of a common bond. The 25th anniversary of the Rome Statute on the 17th of July of this year marks an excellent occasion to further underline this effort and increase global awareness and engagement. Thank you all for your attention.
I would now like to thank our distinguished judges, as well as Ambassador Stehauer and our ICC panelists for their interesting presentations, and to thank all of you for joining us today. Before we close the forum, I would like to kindly ask you to fill in a very short survey, which allows us to gather feedback on this event, which will pop up on your screens now. I will keep the survey on the screen for a few more minutes. And I would like to thank you all again for joining us. And I hope to see you all again next year.
Thank you, Maya, and farewell. Bye-bye, everybody. Have a nice day or a nice afternoon.
Thank you. Bye-bye.
Thank you
Bye.
especially for the judges and all the staff. I think it was very interesting and educative for me, and I also hope for the participants.
Thank you. Bye-bye.
Thank you.
Bye-bye.
Thank you, everyone, and thank you all the participants. Thank you. Hope to see you again. Right, actually, this is my last year as an official, because this is my last year as a judge, so I cannot join anymore next year. But I hope this may continue with such high quality, with many participants of speakers and also students, lawyers from Asia and Pacific region. Thank you for everything you have done until now, and
Thank you, Judge Chung, for your contribution, great contribution for over the years. Thank you.
Yes, thank you.
Thank you.
Bye-bye.